So do I need to make an announcement that we're recording, or she just?
Yeah.
Okay.
That'll be
Okay, so I'm calling the meeting to order at whatever time it is. Looks like 6:34.
6:38.
So this is a hearing of an appeal by Mr. Michael McIlmurray.
McIlmurray.
Say it again.
McIlmurray.
So you do the emphasis on the Mac.
McIlmurray.
Okay, McIlmurray. Of a list decision regarding the property at 317 North Road in Berkshire, Vermont, 05079, parcel 02-94000. Okay, so I think the first thing is for us to identify the Board of Civil Authority. And
Reva Seabold.
Margaret Darrow.
Amy Record. Pat Barnes.
Eddie Wasserman.
Livingston. G. Craig.
So, Andy, I don't think you should be participating.
Randy can be here and maybe ask questions, but she would use herself from any vote.
It actually seemed to me, having some looked into it a little bit, that it doesn't actually pertain to my recusing myself, but I don't want to create any friction and I don't want to make it more complicated.
It's up to you.
Why would it be up to her? Because we don't know the issue that's at hand
No,
exactly.
so you don't know whether you should recuse yourself or not?
I don't think I need to, is what I'm saying.
All right, I will look it up.
I think part of it also maybe is disclosing what your relationship is.
Okay, we'll get to that, but let me find the right page.
I can state why I don't think it's necessary in advance of what she's looking up if you want. Because I thought it had to do with religious affiliation to the Buddhist community, but this has nothing to do with the religious affiliation of the Buddhist community. And my relationship with Greg and Michael is a friend, as is numerous people on this committee. So I don't actually think that I have a bias in that department, because any number of us who know Greg and Michael in the community would have that same opinion, or happen to be also a Buddhist in the Buddhist community. But that, since this, I thought it pertained to pious exemption, but it's really not pious exemption, so that's why I mentioned that. It's an educational community. So therefore, it's up to you guys to decide, and I'm going to leave it in your court to decide.
Okay, so I'm looking at the.
I do not need to delay us any further.
Okay, so here is what it says. Board members must step down from any appeal that involves a relative, et cetera, led by marriage, first cousin. That's not it. In addition, gotta get this down. Board of Civil Authorities members should avoid the appearance of a conflict by stepping aside when former business partners, friends, or enemies appeal their taxes, or in any situation in which the member might not be able to render a decision squarely based on the evidence and merits, leaving personal considerations aside. So what do you think?
I think it's fine. I mean, either way, whatever you guys also decide, but I mean, as a community member, I know I will state that I'm friends with Greg and Michael, but I'm also objective. You know,
Okay.
If it was to side with my Buddhist practice in some way, I would definitely support that. But since it has nothing to do with that, then.
Okay.
I need to say the same. My understanding was I could come and talk and ask questions and then make a decision if I felt like I couldn't make a decision. But I agree with Andy, they're friends, I'm part of the Sangha, but I feel like at this point in life I can make a decision.
I will definitely say if I feel uncomfortable about it.
Okay. So we need to, we definitely need to swear in Pat, who hasn't been sworn in, but maybe we should all Board of Civil Authority re-swear ourselves. Okay. So, let me find the wording of the oath, which I have here. There it is. Okay, so I guess I will swear myself in first, and then I will swear all you in, okay? So I do solemnly swear that you can affirm rather than swear. Does anybody want to affirm as opposed to swear? You want to affirm, okay? So wait until the end. Well, no, I'll do swear or affirm, okay? I do solemnly swear that I will well and truly hear and determine all matters at issue between taxpayers and listers submitted to my decision, so help me God. I do so swear. Okay, so for the rest of you, do you solemnly swear or affirm that you will well and truly hear and determine all matters at issue between taxpayers and listers submitted for your decision, so help you God, or under the pains and penalties of perjury?
I do.
I do. Okay, so listers, appellants, and witnesses. So this is your oath. Do you solemnly swear or affirm that the evidence you shall give relative to the cause now under consideration shall be the whole truth and nothing but the truth, so help you God, or under the pains and penalties of perjury?
I do.
You're a witness?
Not, I'm still a lawyer.
You're not submitting any evidence?
I'm only commenting on legal issues. So, I mean, if you want me to do it, I'll do it.
Yes, I was going to say, I think you're here as a witness.
No, I'm not. I'm here as a lawyer. But I'm happy to do it.
Okay,
I'm not a witness. I'm counsel to the clients, but I'm happy to do it. So would you like to read it again and I'll do it?
okay, I think so. Do you solemnly swear or affirm that the evidence you shall give relative to the cause now under consideration shall be the whole truth and nothing but the truth, so help you God, or under the pains and penalties of perjury?
I so affirm.
Did everybody? I didn't hear over here.
I swear.
Okay. And Mike, do we swear Mike?
He doesn't.
Hmm?
He's going to give testimony.
What?
Is Mike going to give testimony?
I will not be giving any testimony,
Mike?
so I'm just here as the town's attorney. The listers will be giving testimony for the town, and I will not.
And that's what I said. Yeah, so, you know, it would be helpful.
I'm not sure what the difference is.
There is no difference, but I don't care. I mean, it's fine. He can, doesn't matter. He just doesn't do it.
I was unplugging
I
the
did.
refrigerator.
I did. Yes, I so affirm. And I'm not planning on giving testimony, but I'm happy to say that what I want to say is the truth. Good.
Thank you for that clarification.
Okay.
Yeah.
I figure if you're going to be telling us what the law is, that's evidence.
It is. And your lawyer can confirm that. He's not swearing. He's telling us what he thinks the law is. So.
It's not
Anyway,
a problem
okay, all
if the attorney doesn't want to swear in. He's just making legal argument. I have no issue with it. It's the testimony of his client and of the listers that need the oath.
Okay. So, I know the listers have received a copy of the rules of procedure because you got them in the last
Yes.
case. So, Mr. McIlmurray, did you get the copy of the procedures, rules and procedures of the Board of Civil Authority? You did, okay. So the other was, we already talked about whether there are conflicts of interest. And you will decide. Okay, listers. So could you please describe the property that's at issue?
So the application came in from McIlmurray and requesting a exemption on the property at 317 North Road in Berkshire, which you've already identified as parcel 0294 with 35.9 acres. And they submitted the PBR 317 Vermont Property Tax Public Pious or Charitable Exemption. I have multiple copies. Would you like me to give these to Jean for exhibit to pass out to the appellant and the board? Yes, okay.
Is that something that's already, I think we may already have that.
Okay. Would you like?
So that was something that Jean sent out to everybody via email, so if people printed it out, we
Okay,
may
did
already
you
have
see
it.
Okay, you've seen the
One for the
Vermont
file.
form?
The application. Yeah, that's it.
Yeah.
Okay. Okay, so I will review the point that in the request for this meeting today, that the stipulation was that the standards to be applied for this Form 2 PBR that the listers review. The number one is the property must be dedicated unconditionally to public use. If you review the Form PB 317, there are several items that are checked off. I will read them to you. On page 3 of 4. Number 11, who benefits? Are there any restrictions on who may use the property? Yes is checked off. Number 15, does the property promote exercise and healthy lifestyles for the community and serve citizens of all income levels? No is checked off. So our judgment, before we consulted our town council, there were 3 of us at the time. Jamie Blondin has since moved on to another position, but Lucas, myself, for that reason, we would have rejected. The property must be dedicated to unconditionally to public use. It does not fit that parameters. On their website, it is restricted also to students who complete required Buddhist philosophy courses on this website or can show equivalent training. They are subject to availability and dependent upon a given student's background. That is not unconditional to public use. So therefore, it would have been rejected. Upon speaking to town council, he pointed out, because of number 8 on the application, is the property owned and operated by the same entity? Again, checked off on that form is no. And then Attorney Tarrant quoted the Supreme Court case, and that is how we denied the letter. But there is more than one grounds. And again, we're hanging our hat on the unconditional for public use. Did you want to add anything?
I don't think it's necessary. It's really clear. I've just been asking myself contextual questions around public use. And the thing I keep coming back to is, if Meg and I had a fallout argument, would I be able to, in a snowstorm, go stay in one of these cabins? And according to the application and everything that Deb has cited here, if Meg decided to throw me out in the snow, that's not an option. So that is not unconditional public use. So I just keep searching for contextual questions that surround that.
Okay. So following our procedures,
Can you make one more comment?
yes.
Okay. I don't know if people understand when they ask for an exemption, that amount gets picked up by every property owner in the town when it's exempted. The listers take this extremely seriously, that it must meet those guidelines. Because that is not, Berkshire came to us years ago, but that building serves public use. And so it was granted to them. They made argument. And this this situation. We did our research, we consulted the council, we went back and forth to make sure that we involved council. We researched their website, we went over, we discussed it with PDR, our district advisor.
Okay,
I'm
Deborah,
sorry.
you, this was simply to introduce the property that's in question. You get it to make your case later. It's now the appellant's turn to make your case, to explain the reasons for your appeal and submit any evidence. And I understand you've already submitted evidence, so you might identify that as you speak.
Would it make sense for us to introduce ourselves to the press?
Oh, I'm sorry. We should have all introduced ourselves. Yes,
I'll
please do.
do a little bit of the introduction, but also I just want to ask, since it's 6:54 now, how much time we have here, because I was told we'd have 45 minutes, and I want to be sure we
I
have.
think we're going to essentially have an hour because it took us a while to get going here.
And so just roughly what time will we be ending?
Well, I don't know what time it is now.
6:54.
Yeah.
Okay,
We began at
So,
6:38.
well, I guess
Yes, this is 7:38.
7:35, something like that.
Just
Yeah.
hello, everyone. Some of you we've met before and we know. I'm Greg. This is Michael McIlmurray, Greg Seaton. Michael and I are married. And even though he's listed on the title, I am going to be speaking mostly on behalf of both of us today, in part because Michael doesn't like to speak in public, and so he thought it would be there if I did. This is Joe Ronan, who's a lawyer from Sharon, and has also served on similar boards and is very familiar with the process here and the entire concerns that are involved. And he was a consultant throughout the process of building and everything, so he's also an expert in that, in the case, as far as the questions we asked along the way to set this up. Okay, so aside from being married for 25 years, maybe some of you don't know that we bought these 36 acres in 2006 on North Road, and we've been sort of owning them and planning to do something on this since that time. This is a very long time coming, and throughout the time, I've had multiple conversations with Deborah as lister. She's been a wonderful resource for me, and I have been very fortunate to get that advice along the way. I told her from the very beginning what I was eventually planning, and some of her advice turned out not to be correct to me as I checked it out with my lawyers and other people. But when we bought the land, we couldn't move here immediately. We moved in 2013 and rented in the area, and then we built in 2015 finally. And so we've been here since that time. It's just a little bit of background to know. This is not something kind of coming out of nowhere. This is something that's quite long in our minds. Michael works from home as a design consultant, and I am a senior lecturer at Dartmouth College. And I've been there since 2016. To be more precise, I'm a historian of religion, specializing in the history of Buddhist philosophy and practice. I teach courses cross-listed in the departments of philosophy, religion, and Asian studies. You may be wondering why I'm mentioning this, and I think this is going to be actually quite important and central. To keep it very brief and to get straight to the point at hand here, I will say this. I'd like to go to this very central and important misunderstanding that was repeated again by Deborah. It's this, and also it came out in the first notice of the hearing. But in order to get on the same page, we really need to start here. Michael and I are not seeking a tax exemption due to pious use. That is not our request. Not at all. We are seeking two things, and I will explain in 2 paragraphs. Firstly, we would like to have the property taxes that were assessed for the 3 shed buildings to be removed entirely from our tax bill because we do not own those buildings. They are not our buildings. We did not pay for them. We do not own them. We do not operate them as individuals. Instead, the Adimoksha Foundation owns the buildings, paid for them, and owns them and operates them. Adimoksha Foundation had those buildings delivered and assembled by Home Depot. Those are sheds from Home Depot, 16 by 16 sheds from Home Depot that were delivered to the property. And when Adimoksha is done, they will move them from the property. They're not ours to keep. They will move them to another location whenever Adimoksha Foundation chooses to terminate the renewable lease that they have for the land on which they have placed those cabins. This is very different from what is in most of the response from the appeal. And in the initial response, this is constantly being messed up, and we'll speak to that in a little bit more detail later. But in other words, those buildings have only temporarily been placed on the land, and that land has been leased from us as individuals. Okay? So I have provided to you all the lease agreement in some of the documents here. We provided that previously as well. The lease agreement spells out that since March of 2022, this agreement has been in place. Adimoksha has leased this land where the cabins are from us. They're not our cabins. So the ownership of these buildings cannot be disputed in any way. That is, there's nothing that anybody, and no evidence that anybody can present to say that these are not owned by Adimoksha. They are owned by Adimoksha. The land that they lease is ours. So if anyone should pay property taxes for those buildings, it should be the Adimoksha Foundation who should pay those taxes, not us as individuals. So we are asking that, firstly, in the first step here, that those buildings be removed from our taxes since we do not own them. And since they're temporary, they can be moved. They were brought from Home Depot lot, and they can be moved to another place if Adimoksha finds land in the area, up the road or someplace, and it can afford to buy that land. It can pick those cabins up and move them there. They're just the size that can go down the road and do that. Secondly, as a separate but related issue, since the Adimoksha Foundation is a 501c3, tax exempt, educational, not religious, educational foundation is a very different test of what public use is and understanding of what it is. Since it's an educational foundation approved by the IRS to accept tax exempt charitable donations, it is also registered nonprofit in the state of Vermont. Joe, who's sitting here as the attorney representing the foundation, will shortly demonstrate why the law is absolutely clear that Adimoksha Foundation, even though it does own those buildings, should not have to pay property taxes because it's part of its educational program. Now, there's a lot that can be said about the misunderstandings of public use. If you have a school, for instance, why can't I go into the third grade? Because I'm not a third grader. So our restrictions are not excluding anybody from doing this. They just have to go through proper steps. And those steps are safety steps, most of those restrictions, safety steps that somebody can handle going into a cabin and doing meditation retreat. And these buildings are built for meditation. They're not built for something else. But I got ahead of myself a little bit in saying that what is going on here is that there's a misunderstanding, this idea that we are a religious foundation or a religious organization, and that we're looking for some kind of test for that use. The case is not so. Adimoksha is an educational foundation, not religious. It is not a Buddhist organization, and it is not exclusively open for Buddhists. Anybody here at this table can, in fact, go in there for a meditation retreat. You're invited. You're invited. Everybody is invited. You can say, I would like to do a meditation retreat. And a meditation retreat, which is what those cabins are built for, means you do 8 hours or so of meditation a day. You want to do that, and you can prove to us that you are not going to go crazy? You're welcome. You're invited. The courses are to help people understand what they're doing so that when they go into a meditation retreat, they know this is not a restriction against public use. This is just a safety precaution for people who want to go into solitary retreat. And also, we want to know that somebody's not going to tell us they're going in there for 8 hours of meditation and meanwhile be doing painting or writing letters or poetry, even though that would be almost, maybe would make an exception if you really convince us that's your meditation. These are entirely for public use. So the Adimoksha Foundation, I also have to make clear, is not affiliated or connected to Pema Osal at all. It is not connected to the Mangala Shibhuti organization that is here. Zero relationship. And the Adimoksha Foundation, also, I want you to know, leases the land from us for $100 because we are doing this out of our own charity for the public good. We get nothing from this. We don't draw any money personally. We don't have a salary. This is not a business. This is not a business that we're running on Vershire Town's dime. There is nothing that impacts the town. The road that somebody going up there once a month on our road, it's not going to be an impact on Vershire Town. And the whole town isn't paying for that. You're not plowing our driveway, are you? You plow the road. Our driveway, we plow ourselves.
Okay, that's a bit off topic.
Well, it said that it impacts the town.
Well, as Deborah said, the taxes that you don't
Like-
pay, we all pay.
Okay, I grant, and I'm sorry if I was off in that regard, but felt that it needed to be said that this is not an impact on the town in that way. So anyway, these 2 points are extremely important. I'll just repeat them again. We do not own those cabins. Adimoksha owns them. The test of whether or not those cabins are fulfilling the educational use, public educational use, is entirely different from the ones that you've very briefly described off the top of your head. There's a legal definition, brought a legal expert here to talk about them. And I think that you will hopefully see that we're not trying to get away with anything. Adimoksha doesn't even have any sources of income. So please keep that in mind. Now, if there are 2 other things I would say, is that in my sort of background, which is as an educator, I am a professor, I've been educating, I've taught in secular contexts my whole life. I am very clear that this is a form of applied learning to be able to do a meditation retreat. Historically, meditation was always taught in retreat. And I think it's important to say that even though the idea to form the Adimoksha Foundation sprang directly from my work as professor, it was because I discovered that many students in my secular courses on Buddhist theory and of meditation were interested in learning about mindfulness in secular, non-religious contexts in a way that they could apply. Dartmouth gives students, all students who come into Dartmouth are given Headspace app, the Headspace app, for free. And they're encouraged to meditate and do mindfulness. Most of those students who do my class say, we can't learn from this app, and we need to find better ways of educating and learning this. So that was the sort of thing that stimulated me, and I realized there are many people in this world who really don't want to get involved in a religious organization, but want to learn how to meditate in the way that it's best taught, which is doing solitary retreats away from places. So you learn about meditation, you practice a little bit at home, and then you go to a retreat cabin for a week or 10 days or whatever you're able to handle. And in that retreat cabin, you get to practice in different conditions that enable you to go further. And since it's near me and I'm able to give instructions, that's why we thought we would put it so close.
You're going to have to come to a conclusion here.
All right.
And I just had a few things.
Yeah, so I'll just pass for right now and leave this to Joe to take forward. Thank you.
Okay, thank you. So I'm sorry, I can't see you very well. No. So, yeah, I'm Joe Ronan. I'm an attorney practicing down in the Norwich Sharon area. As mentioned, I was on the select board in Sharon for a number of years, so I've been on the other end of this process as well. I just wanted to make a couple of comments about the case law in this area, and that is, the law is a little bit confusing, and it's easy to get kind of lost in the language here. So as was mentioned, the leading case in this area, which I think we mentioned in our short response, is this American Museum of Fly Fishing versus Manchester, and it states three criteria. One is the property must be dedicated unconditionally to public use. Second, the primary use must directly benefit an indefinite class of persons who are part of the public, must also confer a benefit on society as a result of benefit conferred on the persons directly impacted. And the third is that the entity has to be a nonprofit. Okay, so the third is not an issue here. This is a nonprofit organization, 501c3, tax exempt under the state laws in Vermont. The first two get a little bit confusing because you might read these to say, well, dedicated unconditionally to public use and it has to benefit an indefinite class of persons. That would mean everybody in the entire world must be able to use it, right? That's clearly not the case. The case law is clear that there are a whole bunch of restrictions that are permissible here. So, for example, there's a case involving the Rutland County Parent-Child Center that says that organization qualifies. Clearly, they're limiting their focus to parent-child issues. And they also have open hours and closed hours. So to your point about I need to be able to get in there at 3 o'clock in the morning, no, that isn't, it's fair to have reasonable restrictions on the use of the facility. There are cases that say that if you have like an overly restrictive admission process, that you don't meet these standards. So there's a case called Vermont Studio Center versus Town of Johnson, where in order to get in, you had to win a juried art show. And the court there said, gee, that's way too restrictive. This isn't a kind of indefinite class of people. It's the winner of some sort of contest. So that's not good enough. But a couple of cases I'd bring to your attention that I think are relevant here. One actually involves the town next door to me, Norwich. So it's a Stigler Foundation versus Town of Norwich. This is a state-of-the-art dairy farm that applied. And basically the idea was that people could go there and see how dairy farms operate, if that is of interest to you. So of necessity, that's going to be a relatively small group of people, right? It's not everybody, it's some selected group. They self-select, and that's what happens here. People will self-select. The other one that I think is in a way even more interesting, this is what happens when you're a lawyer, you find stuff like this interesting. It's sort of sad, but that's the way the world is. The Zlotoff Foundation versus Town of South Hero, a 2020 Supreme Court case. This is a guy who started his own private collection of classic autos and colonial tools, okay? Then he decided to start a foundation and went in and applied for tax exempt status. The court looked at this and said, you know what? You qualify. And not only do you qualify with respect to the building, but you qualify with respect to the surrounding land that's adjacent to the building because it's necessary for the buildings and the foundation's operation. So again, this is a pretty self-selected group of people who are, I guess, interested in classic cars and colonial tools being found to be tax exempt because that fits. So what I would say to you is, it isn't, I don't think it's appropriate to read these words in a super literal manner to say that it has to benefit everybody everywhere all the time. Because that's not the case. That's not the way the law has been interpreted. Instead, if you can show that there's a definable class of beneficiaries who have a fair shot of using it, and there aren't pre-existing criteria and hoops you have to jump through, I think you meet these standards. And I think that's what those cases hold. So my position, I think my client's position here is that there are three requirements stated in this case, and they've been repeated in probably 20 different cases. This is, I think, a 1989 case, so it's been carried forward in the court decisions quite a bit. I think we need all three of them. The issue, I think we've got a little bit bogged down on some things that aren't really relevant. So the pious exemption obviously is not applicable. The business about who owns the property, I think, got confused. But our position is the owner of the property is the foundation, and the foundation is benefiting from the use of the property. There's also, I think in some of the cases and maybe some of the discussion, there's some concern about facilities that are sort of ancillary to the purpose of the organization. That's not the case here. These facilities are what this organization does, right? In order to carry on its educational purpose, these two facilities do that and only that. So they weren't ancillary, they weren't separate meaning that people use for other purposes. So our position is, this use meets the criteria set forth in the case, and that therefore the exemption should be granted. Thank you.
So, listers, let me see what happens. Listers, would you like to make a response, or did you already
Absolutely.
make your response to begin with?
I'll follow up on that.
Okay, we do
As I
need to
said,
keep an eye on time.
Okay. When we review this form, we have to review it verbatim. And as I pointed out and you've seen, I've already noted the items that they personally checked off as no, that there were requirements, and it did not appeal to public use. And on their website, it clearly states that as well, that there are requirements. So therefore, it is outside of the application and should be refused. I will have Mike Tarrant, I know he doesn't want to weigh in, but he was the one that expressed about the lease situation. As listers, we're going to hang our hat on the fact that there is a requirement, and that is not what the form says. I'd also like to point out that both Greg and Michael are the foundation. They are officers and directors of the foundation. I'm not sure what that legal ramification is. But again, our basis is on our research and the actual application itself. It does not clarify.
Can I ask a couple of
The other
questions?
thing,
Can I ask a couple of
Please
questions of the
do.
appellant?
that's up to the chair.
So yes, you are here as the counsel of the listers, is that correct?
I just,
More or less?
yes, I just have a
Yes,
couple
okay.
clarifying questions. I just want to understand some information better. The cabins, are they just floating on the grass, or are they affixed to it in some sort of foundation?
They are set on a foundation.
Is there
Sitting on
power
top.
or water sewer hookups or anything?
There are.
Is there any deed in the land records that reflects that these are not owned by anybody but the foundation?
There is no deed in the land records, but there is a lease between us and the foundation that allows them to place the things on the land and to hook them up to our septic without having any rights to the septic.
Okay. And you individually are not a nonprofit?
Individually, no. We are board members, and president is Brophy Tyree,
Okay. So the
who's a former.
the landowner individual is not a nonprofit. The nonprofit that you say owns the cabins that are affixed to the property is leasing it from you. All right, I'm just trying to make sure I understand the fact pattern. Am I right about that?
I thought the foundation owns the cabins.
The foundation owns the cabin.
That's the central point here. The foundation owns the cabin, and they lease the land or the access to the cabins.
But there's nothing in the land records that reflects that.
Can I make a lister comment that if somebody had a trailer, they would have a bill of sale that would be recorded in the town. So if they were on a leased piece of land, which we don't have those here in our town, but in other towns there are, that there is a recorded bill of sale. There's no separate deed recording for those structures. And yes, they are quite substantial cabins that were completed and attached to slabs and connected to water and sewer. I'm thinking before the BCA makes a decision that an on-site visit would be required in this situation. I know there is when somebody is contesting their value.
It is part of our procedure, yeah.
Okay, I just wanted to verify that
Okay.
because it's a little different being.
Okay,
Okay, sorry.
okay, hold on.
If I could just draw on one piece of, I'll be very brief, one piece of personal experience. I had sold these sheds for many, many years. This is actually built by Tough Shed. They contract with Home Depot. Within their policies and procedures, they require permanent utilities to be in place. One of the primary utilities in this situation is connected to the private property. All of their septic is connected to the property as a whole. They share the septic. That's the first thing us as listers, in our very narrow boundaries of what we can and can't look at. That's the first thing we look at on a piece of property.
Okay, Board of Civil Authority, do you have questions for the appellants? Yeah, Reva. Appellants.
Sorry.
The Board of Civil Authority has some questions.
I have a question.
Yes.
It seems like the listers are looking at what was on your application. You haven't mentioned in your application and what you said in your application. You said the big picture, but in terms of they're taking literal 8 this, 9 that together, I'd like to hear why you filled them out that way. So if we're going to be discussions on how that application was filled out, I'd like to hear your side of it.
Thank you for the question. Yes, I appreciate that very much. Sometimes these forms don't actually ask you questions in a way that you really know how to answer. I'll just say that in general because they're not made for all situations. And one of those things was about the restrictions. As we made clear on our website, even the restriction that you're supposed to take this class was waived in the case of anybody who had knowledge that was equivalent to that, which was necessary to be able to go into retreat. And on these forms, when they ask you, are there restrictions, as our attorney has just mentioned, there are restrictions doesn't automatically exclude you if you put that. He told us, so we said, no, we should say that there are some restrictions. People, it has to be safe for people to go into retreat. And so that's really, it's not a restriction. So even though that's checked on the box, it's not a real restriction in the sense that they're interpreting it. So that's already been addressed, but that's what we checked and we explained it in the letter and it wasn't understood. And so we're explaining it again. The second thing on the form that was mentioned was that all income levels were not allowed. That is if that is checked on the form, it's an accidental, incorrect thing. Strike that. There is absolutely free for all income levels. It's free. Nobody has to pay anything for anything in this foundation. How could it not be? So that was if that's been checked, that's accidental. I truly apologize if that's thrown us off track. If that's all it takes and we're back on track, hooray. So there's no restriction.
The question is that it does say that does the property promote exercise and healthy lifestyles?
Yeah, so exercise and
I
healthy
think we checked no
lifestyles
because of
is
exercise and
excluded if
healthy
you read the state law. So yeah, exercise and healthy lifestyles are excluded from being exempt. So if you have little exercise groups you want to do. Anyhow, so as far as those two things, and then the question of who owns and operates the property. This word property, I think, is quite confusing, right? Maybe you're all confused now. Does the word property refer to the land?
We already have been through that. We know it doesn't refer to the.
So on the check of the box, the question is, what box do you check? Is the property in question? It's been filed because we received the tax bill and we are the owners of the property, but we're not the owners of the building property. We're owners of the land property. So how do you check that box correctly? And so if there's some confusion there, it was explained in the attached letter. So that's what I'm trying to say is that all these things that were brought up about the form and having to follow the form, that was all, we attached multiple letters and tried to explain this.
I have a question.
Andy?
Speak up without being asked. So it seems to me that the
Oh,
listers.
no, our questions are now going to the appellants.
Yes, but I'm just
Okay.
mentioning
Well, the listers get to make their,
a reply.
okay, and
Whenever
then
you
you
say.
get to ask the listers, okay? Let's try to keep by the procedure. Yes, Jean?
I just have a couple of questions too, and looking at the form, and maybe if the form is incorrect, we should. That might make more sense. But that aside, I was looking at number 8, for instance, on this form through 17. And it says, is the property owned and operated by the same entity? And of course it says no. If no, provide a detailed description of the operator and its relationship to the owner. Do the entities share a single mission? No. Provide supporting documentation. That stood out to me because I know you're teaching and you're going to be on site, and you're there to teach people about meditative practice. You know, I didn't see anywhere in the documentation that I had that really addressed that. Specifically, I mean, yeah, 'cause I think the purpose of that question on the form is, do you have the same mission, and is there something distinguishing the foundation, its practice, and your practice? So I just was curious about that. And I didn't see specifically mission statement. I had this.
Oh, mission statement, I included that in the letter that was,
I may have just.
was included in the original letters. As far as this, I just was trying to address this very issue, and maybe it still isn't clear. When this question asks, is the property owned and operated by the same entity? There are 2 properties. There's one question and one reference to a property here.
Right.
So is the property, already the question is hard to answer because there are 2 properties.
But there's a place there for you to explain, and there isn't anything written there.
We attach, it says provide supporting documentation. We attached an entire
Okay.
letter explaining this
Okay,
because this one line was not going to explain. So we did so.
And if I could just jump in for a second, I didn't mean to interrupt. We're perfectly happy to, provide an updated or revised application. Or also, if there are issues about, affecting filings and things like that, we're happy to do that as well. This is a little bit complicated, there are a lot of moving parts, and perhaps we didn't quite get it right. So, we're obviously happy to corrective action for the actual position. But just to be clear.
So to that end, we're going to agree that PBO 317 would be maybe in the attachment, because if they don't leave a lot of space to describe very well, I put that on this very limited. But maybe in a response letter, instead of just writing a letter describing everything in a 2-page form, that you will say, 1, if it's a question 2, 8. Here's the response. So you try and vision, you know what I'm saying? So it's easy to follow.
Yeah.
Go, okay, there's the form, here's the description. Even if it's not really on the form itself.
Okay, sure, it makes sense.
A little more,
Give you a little more detail.
yeah.
Pat,
And I saw your question.
So how,
Oh, I'm sorry. Go ahead.
so just to be clear, if you said yes to this question, is that what you're suggesting?
I think maybe what we're suggesting is we just need a little bit more detail to expand. There's only one entity. There's 2 individuals and 1 entity, so that's part of the confusion by the ways the questions asked. I'm sorry, you met.
so, Pat has a question.
Yeah, just trying to get, for the children specifically, on 8A, if property, because it feels like, and most of it is running the cabins,
They're owning and operating the cabin.
but you are also involved as a teaching entity. They're an owner of the property, leasing the land to this other foundation. And so I think just clarity would be helpful. And the other thing I didn't see was what land are they leasing? Doesn't ever describe the land under the slab. Is it the land? What is that?
It's described in the lease agreement, which it's the land underneath the slab.
Okay, and again, first time I've seen the lease, I clicked through it, I'm like, I don't see any dimensions, I don't see anything described.
It's just underneath the slab, underneath the slab.
And finally, to Mike's question about septic and water connection. Do each of the cabins have its own electric cabin school? Or is that separately come through your?
There's an electric pedestal for, for the cabins, all three cabins.
Okay,
So it has a designated job. That's what you're
yeah,
asking.
that's what I'm asking.
Pat, did you have a
Yeah,
question?
yeah, I have two questions. Greg, in your opening presentation, you spent some time establishing that the cabins are temporary and just sitting on this what turns out to be a slab. Is that important? Why is that important to your argument?
So this is, thank you for this question. I appreciate it. And it's hard to kind of get across. When Adimoksha Foundation wanted to build, and we are on the board, so, but it's Adimoksha that decided to build, there was this idea that it would be good to have land for Adimoksha, but it was not possible, too expensive in the budget of Adimoksha, and that they would be done temporarily. So that, but the question is, why is that important? Is because if somebody thinks that we are getting something out of Adimoksha personally, that we as individuals are getting something from Adimoksha, which has received these charitable funds and built these cabins, not built them, but bought them and had them assembled. That might look as though we are actually getting these cabins at the end of their lease, but in fact, Adimoksha has to remove them, which is part of its ownership. That's what defines its ownership, that it can take them and leave. If they were cabins that they built on our land and we somehow got them, then somebody might think that we are actually the owners. Because if they leave, if Adimoksha leaves the lease.
I'm sorry, just to be clear, they, when you refer to Adimoksha, it's actually you guys, right?
Well, he's here as the Adimoksha Foundation attorney because it's complicated. Many people have individual relationships to their nonprofit foundation. So you can have a nonprofit foundation. You can even have it pay you a salary if you're working for it. But you're being paid a salary as a contractor to the organization. The foundation pays you for jobs and things you do. So when I'm talking about them, it's mainly to just distinguish conceptually that the ownership of these cabins has to be made clear. So the fact of their temporariness is part of their ownership. They can take them and leave with them. That's a feature of their ownership.
And if I could just throw in one thing too, in terms of the distinction between the foundation and the individuals. The foundation is, is a separate legal entity, and it's subject to rules in its governing documents and the IRS rules that there can't be any reversion for private benefit. Once the property is in there, it has to be used continuously for a nonprofit exempt purpose. So even if, say, the organization decided to liquidate, go out of business, they would have to transfer it to another nonprofit. They couldn't transfer it to the two people here who are involved in it. So I know it gets a little confusing when there's an overlap like this, but as time goes on, I would imagine these folks are going to build out their board. There'll be more board members and different people involved. It's a separate legal entity. It's subject to those restrictions, and it can't just sort of, distribute assets back to them as if there were no distinction between the foundation and that.
I asked my question.
For the listers or for the appellants?
Well, it goes both ways. It's a question for everybody.
Okay.
Yeah, sorry.
Mhm.
What I really wanted to clarify, because I'm I'm listening to the conversation, is that if the appellate decides to rewrite their the paperwork that's required to check the boxes correctly according to it, would that appease the issues that you have both as listers? I mean, I'm just making sure that if the appellate goes to the trouble to rewrite their questions, will you be open to reconsidering? Because it seems like I'm trying to understand if this is a really fait accompli and it's already been decided by the listers, or whether the Board of Civil Authority actually can weigh in on this, or whether in fact, if they rewrite that, it's understood that there was a misunderstanding there, it seems to me, what I'm understanding, based on the paperwork. So I'm trying to unstick the problem. Is that a possibility?
I would feel free to welcome, I'll
I
answer
would be
that.
happy to review it.
I would
But
think that
it
the
would-
Board of Civil Authority has that authority, yes.
I would answer that it's a multifaceted situation. I still don't believe it fits the parameters. We've not considered it as a pious use. We took it as just a generic application, even though they're hanging their hat on that. We did the research to see what the requirements were. It does not fit the parameter that anybody can use them at any time for that particular PDR form, period. As for the other facet of the leasing, and not knowing who owns the cabins, they're not reported as a separate deed. That we'd have to consult with council about. The lease thing is still something I would want to consult with town council about. That's why we held off on our decision until we could converse with council about that. We put a lot of effort in this. The ground lease also refers to the fact that it's a 25-year lease and they can add additional cabins. Are we going to be back and they're going to ask us for more cabins? There's a lot of facets going on here, but I personally, and with consulting the two other listers at the time, prior to consulting town council, we felt it did not fit the parameter.
But based on the evidence that we were given today, which is quite different, it sounds like, than what your initial understanding might be. It seems like there might be some give, because I don't understand how I'm trying to understand my mind. When you say it has to be free and unlimited at any time, but they're saying that's not the actual law from their council. I want to
That is
understand.
one of the many cogs that Deb is referencing and they are as well referencing. That is one of the many pieces of the puzzle.
And
We will,
Thank you.
a reasonable argument has been presented and
I would just
we would reconsider an application,
Thank you.
absolutely.
appreciate that. I would just restate that the concept that anybody can use a facility at any time is not what the law says. And the case law doesn't support that. And your counsel will at some point comment on that. I'm not going to put them on the spot. But if you look at the cases clearly allow reasonable restrictions. Again, if you look at the case that I mentioned, the Rutland case about the parent-child center, do you think anybody can walk in there at any time and say, I'm staying overnight? They can't. There are reasonable restrictions in place about use of the facility, and it has to be tied to the purpose of the facility. I would also say, and your counsel can help you with this, the Zlotov case is actually sort of interesting to me because that taxpayer, the petitioner, kind of mucked up a number of procedural things in that, and the court, and this is the Supreme Court of Vermont, said that they still qualify. What we're looking for here is whether they meet the standards of the statute, and we're not going to spend a lot of time. They apparently hadn't gone to the town and gotten the right kind of permits for their foundation building or whatever they're supposed to do. And the Supreme Court said, that's fine. They otherwise meet the requirements of the statute. Good enough. And as I mentioned to you, the Supreme Court said,
Could we agree though that you're interested in reasonable equity?
yeah.
Okay.
My clients want to present their case to you, give you a fair chance to
Reasonable
understand what they're doing, and come to a conclusion.
Okay.
Okay, so at this point, we would ask the listeners to make their case, but you've already done it.
Well, I do want to say one more thing, that these are
Okay.
clearly not temporary structures. No way, shape, or form, it would be almost impossible to lift those things up and extremely expensive to move. And you'll see that when you go and visit these properties, which we were out at, and so was the outside appraisal firm that they have. They are clearly attached for long-term use and could serve multiple purposes down the road if the lease was to be renewed.
Okay, so,
The policies of Tough Shed themselves are extensive and do require it to be a permanent shelter. To uphold any warranty, anything.
May I briefly respond to that?
okay,
25 years is the long time, and the Tough Shed warranties and things are around 25, 30 years.
Okay.
So the lease is for 25 years, and by permanent, that we have to clarify, we want them to be lasting for 25 years, and they're built that way to last for 25 years or more if the Animocha Foundation wants to renew its lease. There's no question that they've been made solid and made to stay. But if Adimocha Foundation cannot continue to lease or operate, then Adimocha Foundation will have to either move them or destroy them or take them apart, because that is not allowed that they come to us. This is not our concern here. This is the IRS's concern later. If this comes back to us in any way, then that would be a question for the IRS. It's not a question for our property taxes at all, as far as I understand it. Am I correct, Bill? Or-
Well, I mean, I guess we, at some point we'd be interested in discussing that further with you, ultimately, why that matters that much to you. I mean, yeah, it's a big structure. I'm not an expert on moving big structures, but I see them moved on the highway periodically with big flashing lights that say, don't try behind this, right?
That's
So,
before they're mounted, though. That's before they're mounted. These are now mounted. These are attached to land.
okay,
They're not like a mobile home sitting on launch. These are physically attached. And also, I want to point out in the lease that the foundation paid the sum of $500,000 for construction of these 3 5x12 cabins. And we don't have anything that shows a bill of sale to anybody.
We are happy to provide tax returns. You can see all of the accounting for the foundation to see that it's paid all of this. It's been listed with the IRS.
There's no bill of sale recorded, there's no deed. So that's another missing piece at this moment in time.
So we'll include that with.
Well, then that's a conversation that needs to be in another.
Well, we have a further meeting in which you can provide that information.
okay.
I also could add something.
Huh?
I could add one piece of information.
Are you acting as a witness?
No, I'm just gonna, something that I happen to know about the project. They mentioned.
I would just like to finish before we.
Okay.
We, as listers, I'm going to say this again, we operate within very strict boundaries that require us to ensure equity amongst all of the citizens. And that is the first priority for us. We're not out to get anybody. We're not accusing anybody of anything. So none of that. We operate within very strict guidelines. There are a lot of moving pieces here. Everybody in the room said it. When we look at this, it comes down to a lot of things, but mostly the citizens of this town, people who own the parcels in this town. At the current tax rate, this cites an increase of $621.40 per parcel in the town. Okay, we're also asking for back taxes back, I believe, and if additional buildings were put in, that would be additional cost to the other 500 and so parcels in this town by providing a tax exempt status in the situation. So we don't just look at the fact that the septic is connected to the private property. They do have their own electrical, but that septic is connected to the private property. That is one septic owned by.
They all have their individual tanks. They pump from their individual tanks to the common septic.
Maybe they go into tanks, but they go into one leach field.
Yeah.
So your septic design is for 6 to 8 bedrooms, as I remember.
Right.
I know.
So, but
6 to 8.
to the point, equity, we are right there with you. And we're looking at all this stuff too. But at the end of the day, we also have to look at what it means to everyone else in this town. And you're providing a lot. I'm absolutely conceding. I got off on the wrong foot with you, but $621 increase to a lot of people in this town. That's a lot.
I don't understand how that could be.
That's their taxes would go up with the exemption.
With the exemption for what, 6,000?
No, I put the decimal in the wrong spot.
So, yeah, it can't be that.
Because additional money, those taxes, and of course, every year they're different, those would be broken down between all the other people in this town because of that exemption.
So
And if it's not for everybody's use, that's where the listers have a problem.
Vern,
Just some clarification. You own the property,
the land,
the land. Who is the foundation that owns the buildings?
the foundation is a separate entity and we are on the board of that foundation.
But who actually is the foundation? The board of directors, who is on the board of directors?
So you want to answer this? Well, I mean, I just answer it the way I answered it a while ago. The foundation is a separate legal entity. It's a 501c3 not-for-profit corporation under Vermont law and recognized by the IRS. So it's a separate entity. It owns the cabins. The entity is controlled by its board of directors, which at this point is a small board of directors because it's kind of a startup. Over the course of time, that will probably grow. But the board of directors has fiduciary obligations with respect to the entity. They can't act in their individual capacity. So it's a legal entity. The foundation owns the cabins. People in their individual capacity own the land. They have contractual relationships, that have been laid out. Does that help?
No.
Let me,
Who is the board of directors? Who is the
The
entity
foundation
that owns?
is a legal entity. The board of directors isn't.
Who is the foundation now?
It's a legal entity that has been established under Vermont law. It's like asking who is IBM. I mean, it's an entity under the law. Now, can you tell him again who the members of the board are?
Michael, myself, and Brophy Tyree, who is another resident of Vershire, are the board members at present. We may add more board members, and we may cease to be board members of the foundation at any time. But that we are the present board members, the founding board members. That's
The
what
501c3 exemption was granted to the foundation as a legal entity, as a not-for-profit corporation. It wasn't granted to the board of directors. It wasn't granted to these individuals.
Let me just make an analogy. This is not the same at all, but imagine somebody has a house and they have a car and they're a plumber or an electrician, and that is an electric car, and a car with full their electric equipment. Is that the owner's, is that your car or is that your business's car? It's your business's car. You get to write that off. You get to expense it. It's under your business. So this is a nonprofit business, if you will, that is in our name, but it's the nonprofit business status doesn't come from us saying it's a nonprofit. We had to go through application process to the IRS to establish that what it does is nonprofit charitable work. So it's not a plumbing business that we can write off the car or say, this is not our car. My plumbing business owns this car. I just drive it for business purposes. I have another car that I drive to the supermarket. That separation is a similar problem. So here in this situation, what you're saying is this our business? Is this somehow just us acting as a business? No, we actually perform functions of a nonprofit business, charitable functions. And those things are not remunerated at all. That's why that nonprofit status is tax exempt. And there's no income coming in for doing that, or no rent being charged for the cabins. This is a very important thing to understand. All the money for those cabins was donated by other foundations for charitable purposes, and they identified that this was a charity that they wanted to support. So that is something that has to be understood.
Can I add one comment? Okay. Speaking, I happen to know Brophy Tyree, and the cabins were the brainchild of Brophy Tyree, actually. But because they designated in their meetings that the cabins would would be placed on the land here, it made sense to have Michael and Greg be part of the foundation because they can oversee those cabins because they happen to live on that land. You see what I'm saying? They can administer.
I think
Okay, do we have questions for the listers?
I just want to clarify that you will accept the reports done again or redone or
The application.
the application.
The application.
Sure.
Of course, we'd always accept an
And
application.
that if there was an application that you could change, you could legally change your opinion or your judgment.
We would get an application which we would review. I can't answer how we review it because again, there seems to be some missing pieces here of ownership.
But it's within your
We can
jurisdiction
review it, but we
to
can't
review
change
it. And if you should decide that it meets the criteria under the new application, and you change your opinion. Notes, can you,
It is
It would be
possible.
a new, it would be a new opinion. It would not be a change
Okay.
of opinion. It would be a whole startup, a whole new startup.
whole new startup?
It
Okay,
is not outside the realm of possibility.
thank you. That's what I wanted.
Can I just chime in
Yeah.
real quick? I think what we're doing here tonight is they're asking the BCA to rule in contravention to what the listers ruled. And so if the BCA concludes that the listers are wrong and that the appellants are correct, you guys will simply enter that the exemption would be sent to the state. If you don't agree with them, then it won't be, and they'll have their right to appeal to PVR or the Superior Court as they may. So it's up to the BCA in this instance. If they withdraw the application and reapply, then the listers would review it again for the next tax year.
Can I ask you, are you saying that we don't, if you understand the corrections to the form, a new form doesn't need to be?
If the
Uh,
BCA
filled out and
agrees
applied?
with if the BCA agrees with your argument today that the listers were wrong and you are correct, the BCA implements the exemption and it goes to the state, and that's that. If they don't agree with you, then it doesn't, and the tax goes forward unless you appeal to PVR or Superior Court.
But my question is, by agree with us, do you mean that they have accepted our clarifications of the answers on the
Okay.
application?
Okay, I can speak for the Board of Civil Authority. So we will write a decision. And the decision could be either that your appeal is accepted or your appeal is rejected. Okay, if your appeal is accepted, then there's no further action that you need to take. The exemption would be accepted. Okay, if we are to reject it, then you could appeal it further. You could, from what I've understood from the lifters, refile with more evidence, the form made out in a way that was clearer to exactly what the situation is. And we could go through this again.
Well, just if I could ask a clarifying question. I think your attorney stated that if we refiled, it would only be applicable to the next tax year.
Right.
Right? So that's not refiling that would have an effect on what's being discussed here. It sounds
No,
like his
would be
position is
Next.
your
next
choice
year.
as the board is either to accept based on the evidence that's been presented or reject.
Exactly.
There is no revising at this point with respect to this.
I think that's the case. I imagine perhaps we could revise. Yeah, Gene?
So I think I introduced a little bit of uncertainty in the operation and asking for more clarification for number 8, really was the one that I wanted. But so I think the question might be, for you, Peggy, and for maybe Mike, is that my understanding is that the Board of Civil Authority could ask for more clarifying information. I wasn't asking for you to reply to the PVR. I just wanted more clarity on the form itself. So maybe it's just
That's true.
It is, but clarifying in a separate document. Yes, we met at 8, 9, and 10. Meant this and this and this.
And we're happy to do that.
That's what I was asking.
We're happy to do that. if
Okay,
that's an acceptable step.
So yes, so just to make sure you understand what's going to happen next. So there'll be an inspection by a committee of the board of the property. And then the hearing will, what is it called? Be recessed. And then the hearing will be resumed within 30 days. And you would be able to submit more evidence, clarification, et cetera, at that point. And listers can also do so.
Thank you. Finish.
No, listers can also submit any more evidence or that they would like to submit.
My comment is, we made our decision on what was in our hands.
Right.
So for that to now be revised, I have a bit of a problem with that from a review point, because now it's a new ball game that we've got they're asking for revision. We made a decision on what was in our hands and our research and our counsel.
Right,
So I'm just saying,
right. But I mean, this whole process involves getting evidence from you, from them,
correct,
right? So,
understood.
Yeah.
And may I also ask, there's another person that's noted on the officers and directors, and nobody's mentioned Nicholas Stone Blasey. Who is Nicholas Stone
He's-
Blasey?
He's not on the board anymore. He was originally going to be on the board, but he's not.
Okay, well, he's on the form that was submitted to us. Plus, the other complication is when the form came in with the accompanying documents, it did not have the address of 317 North Road. It had the address of 993 Darling Hill Road, which took some research to figure out. We didn't want to impose upon the owner of that property to say, why do we have an application with somebody else's address on it? So that was very confusing.
That's the address that was given to the foundation in the original application for the IRS. And that's because Brophy Tyree had that as his mailing address.
Okay, but that should have been revised with, this is what we got submitted, and we were told at some point with the rebuttal that you would change the name of the organization too, from Amamoska to Orca.
DARPA.
Thank you.
Because see
So
how
in
hard
other
it is to
words,
say
that's
Adimosa,
been
we
revised
needed to
too,
change it.
since all of this has started. So I mean, who is getting the exemption and who owns what? These are just things that we've heard outside of beyond our initial decision. You know, the address is wrong, the directors, now the name of the corporation, there's no record as to technically who owns. And again, in that lease that you filed, that you gave us to accompany, it clearly states somebody got 500,000 and it doesn't say where that came from or where it went to other than building these cabins. But there's no paper trail.
There is a paper trail. I
We
told you,
don't have it.
I don't think you need it. Paper trail, the entire paper trail. Every little thing that has been done. I don't think you need the entire paper trail. All you need is proof. All
Right,
you need
but
is
it doesn't
proof.
say who to who. It doesn't say who to who.
May I imagine? All you need is proof that Adimoksha owns the cabins. And that much, you're not the IRS, you're not here to examine Adimoksha. All you need to know is that they own the cabins and that they got money, they spent that money on the cabins. That's something for the IRS to look at. That is not involved in our property tax here. If you're disputing that they own them, which you are,
We don't have a deed.
You're-
No bill of sale and
just
no
saying,
deed in the
the
record.
dispute about whether they're owned, we said we will get you some paper.
okay.
And that
okay,
starts
let's-
at a new.
Let's,
And that starts
let's
at a
stop.
new.
No, I'm sorry, let me just, what I heard said was you would be willing to take a submission that would clarify.
A withdrawal in the application.
That
This
isn't what your
decision is
policy
on
said.
this.
That's
What
what I
I'm
said.
saying is
Okay.
it starts new.
What I said is that we have a resumed hearing in a month,
Yes.
and we will accept more evidence from either side at that time.
Right. We will try to clarify all the things that you're finding unclear. But I just want to, I think it would be fair at that point to continue to consider this in terms of the current year, rather than saying that any supplemental material causes it to be a resubmission.
No, okay, you said you understood this process. Okay, when we make a decision, it will be after that resumed
I
hearing.
understand that, but
On the basis-
that's not what I heard from that side of the room.
Okay, but if we make a decision in your favor, then it's for this year. Okay, if we deny you, right, then you can go on to upper levels, or you can submit a new application.
I
And that
understand.
would not be for this year.
My question relates to any further submission during this interim period.
Right,
And what I asked was, if we try to respond to all the points that are being made about the unclarity, would that be taken into account in arriving at the decisions for this year?
of
And not
course,
be viewed as
that will
submission?
be submitted to the Board of Civil Authority. The listers are not involved in that decision. We
That's
are.
my take. Okay, so they've
Okay.
said several times it would be a resubmission. It's not a resubmission. It's not intended as a resubmission.
No, but I mean,
Shows we should.
okay, we're already over time. Okay, we need to set up an inspection committee. The listers can be part of that inspection committee inspection, but only if you so agree. They don't necessarily need to be, but for your appeal to go forward, you have to allow the inspection by the Board of Civil Authority. And if you don't, then your appeal is null and void. I just want to make that clear. Okay, so who would like to be Vern, Reva, Pat, and Amy? Okay. So, a date? Someone suggest a date?
Uh,
What, I
Next
mean,
week.
one or the other of you will need to be
Yeah,
there.
Next week. As long as it's not the 22nd.
What's a good date?
I'm open, so it's,
I can be pretty flexible.
Well, somebody's got to suggest something. Everybody's being flexible. Be flexible here.
Saturday.
Impose
Nope.
something.
Not Saturday, Amy says. I work Saturdays.
No, it's this Saturday.
2 days.
no, it's too much going on this Saturday.
Okay. So
Not Saturday.
How about the
There's-
15th, Tuesday, the
There's
15th?
6 other days, okay?
Tuesday, the 15th.
what time?
Daylight hours. Say,
Tuesday is what day?
The
15th
15th.
Tuesday, the 15th?
Yes,
Does that
that's
work for
fine.
you guys?
afternoon?
Afternoon,
4 p.m.
Okay.
4 p.m.?
Sure.
Okay. For the resuming of the hearing, 30 days from today is Saturday, November 9th. But we don't want to do it then, on Saturday. How about Wednesday, November 6th?
The 6th is Tuesday, it's election day, so Wednesday will
Oh.
be fine.
Wednesday is this, Wednesday, what, the 7th? What is? Must have got, I'm terrible with getting up dates.
Thursday, okay, 6th is.
Could it be the week before? In the end of October, is that possible or is that too short?
Well, the inspection committee has to write a report, so you have to give them time to do that. They're doing it the 15th. How long would you need for a report? Should we say, could you do that in a week?
Before November 1st.
You want to do it before November 1st? I don't have a calendar in front of me. I don't know what days of the week anything is.
August the 6th.
Wednesday the 6th.
So how about we resume on Wednesday, the 30th?
For our report. Or for them.
No, for the resuming the meeting.
Okay.
That would give you essentially 2 weeks to do your report.
That would be at
October 30th.
That would be at 6:30.
Yeah. Does that make sense?
You said the 30th?
Yeah, the 30th, 6:30.
Happens November 6th, is that out?
Is that okay with everybody?
So I'm sorry, you're saying the 30th?
Mhm.
Okay, can we have that 6:30? Does that work for you guys? Yeah, okay.
Does that work for you, listers? Okay,
Sounds good.
okay, Pat, use your phone. Thank you. Okay, so the hearing is now,
Why don't you go ahead and say that?
Just to clarify, you said it's up to the appellants whether or not the listers would go, and
right,
the listers have already been there.
right. They could come, They-
I would prefer if they don't go
okay,
again.
that's fine.
So that's the simplest way.
Okay, so our hearing is now recessed until Wednesday, October 30th at 6:30.
Good, thank you.
Thank you very much.
Thank you
Yeah,
very
thanks
much.
for your time.
Yes.
Sorry if I was a little excited. It's hard when it's you